When a homeowner dies, their property goes through a process called probate before it can be dealt with or sold. That means a lengthy legal process and probate fees. But there's a little known exemption that can avoid that process altogether. As a lawyer who focuses on real estate transactions, I deal with estate properties regularly, and I see this exemption come up a lot more often than people think. So if you're an estate trustee dealing with property, or a realtor working on an estate sale, this video can save the estate both time and money, but only if you know what to look for. My name is Zachary Soccio-Marandola. I'm a real estate lawyer here in Toronto. If you enjoy this type of content, make sure you subscribe and join our community. And if you have a closing coming up, we've built the most transparent legal calculator online. It gives you a full breakdown, even calculates closing costs like land transfer tax and title insurance. That's linked in the description below. Now, before we get into the exemption itself, let's talk about what probate actually is. When someone dies in Ontario, their estate goes through a process called probate. That means the court formally appoints an estate trustee, usually the ones named in the will, and this grants them legal authority to deal with the deceased's assets. Now, for real estate, this means to sell a property, the estate must have the certificate of appointment of estate trustee, and to get that, you need to pay estate administration tax, or in other words, probate fees. So how much is that tax? In Ontario, the first $50,000 of the estate's value is exempt. Everything above that is taxed at 1.5%. So for an estate worth $800,000, you're looking at about $11,000 in probate fees just to be able to sell or dispose of the property. So let's talk about that exemption. This, of course, is the First Dealings Exemption. It's a provision in Ontario's land registration system that allows certain properties to be sold or transferred without going through probate. So no estate certificate, no estate administration tax. The idea behind it comes from when Ontario converted its old land registry system to the modern land title system. That conversion happened across the province, and when a property was converted, it was given a fresh start in the new system. The exemption says if a property has not been dealt with since that conversion, the first dealing, meaning the first sale or transfer, can happen without probate. Now, not every property qualifies, and there's three main requirements, and all three have to be met. The first requirement is the LTCQ qualifier. That stands for Land Titles Conversion Qualified. It's a designation that appears on a property's parcel register under a field called Estate Qualifier. If you see LTCQ there, it means that the title was originally registered under the old land registry system and was converted to land titles automatically. If the property does not have this qualifier, then the First Dealings Exemption is simply not available. The second requirement is a valid, unprobated will. The deceased must have left a valid will, and that will must not have been probated. And this is an important detail. If someone started a probate application for the estate and the will was probated, the value of the real estate goes into the estate administration tax calculation. Even if it would have qualified anyways, it gets automatically pulled in. So the will needs to be in place and untouched for the exemption to work. Now, the third requirement is that there must not have been any dealings since the conversion date. This is where most of the analysis happens. The conversion date is listed on the parcel register, or what people call the title search. So every instrument registered on title after that date needs to be reviewed. If there was a dealing, then there's no exemption available. Now, inevitably, the question becomes, what counts as a dealing? This is where it gets a little tricky, because there's no official definition of what exactly constitutes a first dealing and what doesn't. I know, it's not the most helpful answer, but here's what we do know. A sale is a deal. So if the property was sold after the conversion date, that exemption is no longer available. A transfer, even to a related party like a spouse or child, is also a dealing, even if there is no actual money exchanged. Now, a mortgage is not a dealing. So if the owner took out a mortgage after the conversion, that alone doesn't disqualify the exemption. And a survivorship application is not a dealing. So if the property was jointly owned, one of the owners dies and after the conversion date, and the surviving party registers their survivorship application to become the sole owner through the rights of survivorship through joint tenancy, they retain the rights of the First Dealings Exemption. So how do you actually find out if a property qualifies? You have to review the parcel register. That's the official record of the property's title history in Ontario. You're looking for two things: the LTCQ qualifier under the estate qualifier field and the conversion date. Once you have that conversion date, you review every instrument registered after that date and assess whether any of them are dealings or not. Now, you can pull a parcel register yourself and take a look, but at some point, your real estate lawyer will need to review it and confirm, so often it's just best to start there. Now, before we go, we need to clarify an important limitation of the exemption. If there are other assets in the estate that require probate, the value of the house gets pulled back into the estate administration tax calculation. Even though the property qualifies under the exemption, the benefit of the tax savings goes away because there's other assets requiring probate. So, unless the property qualifies for the first dealings exemption and is the only asset that otherwise would have required probate, or there was careful estate planning that involved multiple wills, the tax saving benefit may not be available. So keep that in mind. If you own a property that may qualify for a first dealings exemption or know someone that does, conversation with an estate planning lawyer might be valuable to protect that future benefit. So that's the first dealings exemption. It's not a loophole, it's a legitimate provision in Ontario's land registration system that might save an estate both time and money. But it only works if someone on the file knows what to look for. If you're enjoying these behind the scenes real estate law videos, make sure you subscribe to the channel. I post a new video every week. And if you're a realtor, I also send a weekly update about different legal situations that come up in our closing. That's our Realtor newsletter, and you can subscribe to it with the link down in the description. Thanks for watching.